Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications, exercise number 5 and 6 on the speed of 90 words per minute. Start. The case of the petitioner is that under the service rules, the period of probation prescribed is 1 year, and since no order was passed extending the period of probation and consequently he would be deemed to have been confirmed in December 2000. It is urged that the probation could be extended by a maximum period of 3 years, which expired in December 2003. Thereafter, his services would be deemed to have been confirmed. There was no justification in not confirming him in the year 2005 or in postponing the issue relating to confirmation on the ground that his services had not been found to be satisfactory. It is urged that the same mistake was committed when the respondent refused to confirm the petitioner in October 2007. It is further submitted that at the relevant time there was no adverse entry in preceding 5 years. The solitary adverse entry of the year 2001 2, being an entry more than 5 years old, could not be made basis for not confirming the petitioner and in denying promotion to him. The warning issued by the Registrar General by order dated 12/6/2007 also could not form basis for withholding confirmation or denying promotion to the petitioner, inasmuch as a warning is neither an adverse entry nor a punishment under the service rules. It is pointed out that a preliminary inquiry in an other matter, which also formed the basis for denying confirmation, has culminated in favor of the petitioner, and thus the same could not have been the basis for denying confirmation in service. The writ petition was opposed by learned counsel for the respondent by contending that under the service rules, although a maximum period of probation as well as extended period of probation are prescribed, yet there is no provision of deemed confirmation. It is submitted that the appointing authority is enjoined with the duty to assess the suitability of a candidate, and he is confirmed only if he is found fit and his integrity is certified. It is urged that in the case of the petitioner, his work and conduct was not found to be satisfactory. It is submitted that in the year 2001 2, there was an adverse entry against the petitioner, followed by another adverse entry in the year 2004 5, which though was expunged later on. It is submitted that in the year 2005 the case of the petitioner was considered for confirmation of his services, but it was found to be unsatisfactory. Consequently, the matter was deferred. It is pointed out that in a departmental proceeding held against the petitioner, he was found guilty of indiscipline and misbehavior with his superiors. However, the respondent, taking into consideration the unconditional apology submitted by the petitioner as well as the fact that it was first such instance, took a lenient view and instead of awarding any severe punishment, he was let off with a warning to be careful in future and be a disciplined employee. The benefit of pension is a condition of service. It is clear from the scheme of regulations that an employee would qualify for pension provided he meets the requirements envisaged under the civil service regulations. It is well settled that the conditions of recruitment cannot be relaxed and recruitment resorted to dehorse the statutory rules is a nullity. The authoritative decision in this regard rendered by the apex court in case of State of Karnataka versus Uma Devi 2006 4 SCC 1 lays down the law. When we analyze the petitioner's argument from this standpoint, a daily wage employee, in our considered opinion, cannot be equated with a regularly selected person. The apex court in a catena of judgments has spelt out the distinction. Therefore, the classification based on the recruitment by following due procedure under the rules and through backdoor entry is well recognized. Once the classification in the matter of recruitment is recognized distinguishably, any challenge to a provision which grants protection of pension to the requisite length of substantive service alone would be misconceived and contrary to the spirit of Article 16 of the Constitution of India. We may safely observe that any challenge to the validity of Regulation 370, which leads to diminish the distinction between the valid recruitment as per rules and backdoor entry, is clearly an attempt to equate two unequal and distinguishable situations which have rightly been classified under Regulation 370. For achieving the goal of Article 16 of the Constitution of India, it is essential to draw such a distinction, and the same would not impinge upon any fundamental right available to the petitioner under Article 14 of the Constitution of India. As such, challenge to the validity of Regulation 370 fails. The petitioner in the instant case has not offered any justification as to how a daily wage employee can be equated with the employees who are recruited in service by following the stringent process of recruitment. The services rendered by a regular employee, for that matter, can neither be equalized in terms of financial implications nor treated at par with the services of a daily wage employee unless the rules so permit. Now, coming to the judgment placed reliance upon by the petitioner, suffice it to say that the case of the petitioner is governed under a different set of rules. The petitioner has also not laid any foundation for establishing equivalence of his daily wage services to be at par with the services of a regularly recruited confirmed employee. Even the right to hold the post prior to the date of his regularization in a substantive capacity is not established or construed in the light of any statutory rule, and it is also not made out as to how payment made to the petitioner out of contingencies may be treated as regular salary. This writ petition has come to be filed after about 2 years from the date of petitioner's retirement, and that too under the garb of challenging the validity of Regulation 370, which is clearly an afterthought.